I actually used him in a murder case that led to an acquittal. I also know the prosecutor, Richard Buxton, might try a case against him. I know a lot of people involved, but Dr. Anderson is extremely, extremely articulate, and I respect his opinions. I think personally, just on one small note, if I have to give a little air of criticism, I would prefer him in person rather than Zoom. I don't like that cluttered background. It's a bit distracting to his testimony. But I think he makes a better impression in person. So I don't know if there were some medical issues or COVID issues or what prevented him coming in person. But he is an extremely talented and respected doctor. And as I said, I used him in a case where he gave a very detailed explanation about injuries to a wrist that led to an acquittal. So they chose the right person to help them. It's just unfortunately you're dealt with those facts and there's only so much a doctor can do. But he made an interesting point. And of course, the state had their own expert that contradicted that point, and the jury believed the other expert.
Yeah, no question about it. Now, I want to go back to those appealable issues that we talked about. The court talked about perhaps appointing someone for the appeal, but it sounds like with your discussion with Jervis Wise that he may stay involved through the appeal?
Right. Well, I think Mr. Wise was appointed for this case firstly, as opposed to retained. He does both retained cases and appointed cases. So if he was appointed for this case, it makes sense that the appellate court would appoint him to the appeal. He does specialize in appeals. So I'm sure he had knowledge. Obviously, he wrote the motions and he argued the motions, so he would be in the best position to write the appellate brief and argue before the DCA for relief on those appellate issues. So I'm sure he'll be appointed for that purpose. But as we all know, and as you pointed out, irrespective of how strong your appellate points are, statistically, appeals are very difficult to prevail. And an issue with the domestic batteries, for example, the appellate court may say that it was error for the court to let it in. I'm not suggesting they will do that or speculating, but hypothetically, if they did do that, they may come, if they often do, to the conclusion that maybe that was possibly error. However, it doesn't rise to the level of non-harmless error. And it still may say the evidence is so overwhelming that we don't find that issue enough to overturn it. They may, on the other issue, if they give a written opinion, that's a whole different situation, because finding the body, the consent to find the body in the whole case is certainly a whole different level of appellate grounds. And if they rule in favor of the defendant on that, the whole case could be dismissed.
Yeah, and I want to dig into that a little bit because I think it's important for our viewers to understand there's this saying in criminal law about the fruits of the poisonous tree. So the point being that if, in fact, they find that that search wasn't right, because, of course, the claim is that his girlfriend at the time, Patience, she didn't have the right to let them into his cabin. Now, the state argued that she did because she had clothes there, she had spent time there, and so she did have the right to give them consent to go in and search the house. But if they find that the search was against his constitutional rights, anything they found in there falls, correct? And I think you're claiming that Jervis believes if that happens, they have enough there to rise to the level that that is not harmless error, that that really would have affected the outcome of the trial.
Correct. And I think what's really unique to this argument, which is unusual, is generally in a case, you suppress the evidence. And so you can go forward on other evidence in a case like this, even if the body in this case, which was the suppressed evidence, the issue at hand, is suppressed. His position is that this is dispositive. And if you don't allow the police in, you don't find the body, you don't get to the case, so the whole case should be dismissed. And I understand that the judge did not rule whether this was a dispositive issue or not, because if, for example, he had ruled this was a dispositive issue and the appellate court agreed with him, then not only is the evidence suppressed, but the whole case is disposed of, is dispositive, and the case will be thrown out. So that's the more intricate, interesting, and unusual appellate issue. The law on searches, you either have consent to search, you either have the right to give consent to search, or you have the apparent right to give consent. Someone that's staying can give consent, for example. Someone that's temporarily can give consent to search. And that was the state's point, that she had the apparent authority to consent. But what is interesting is the other legal argument I mentioned before. If the appellate court rules she didn't have consent, does that mean the body is suppressed? Or does that mean the whole case is thrown out?
Yeah, and that actually answered my next question, because my point was going to be, well, you still have all the statements of the defendant. Certainly they could go forward on that and the judge would look at that. But you're claiming that part of what Mr. Wise is going to argue is that without the finding of the body, then they never even get to the statements. So that would be not possible to use as well. And in fact, the entire thing falls and he would then be free to go.
Right. And as you know, as lawyers know, the nature's corpus delicti, the Italian, the old phrase, not the Italian phrase, the Latin phrase, corpus delicti, you can't prove a case on admissions alone. So the corpus of the case has to exist irrespective of the statement. So they could not go forward just on his admissions. If John Smith says, I killed Jamie Smith, and that's all you have, that's not sufficient. You need a corpus delicti. And his argument is, there's not a corpus delicti. So if you take out the statement, there's no corpus delicti to go forward, which is an interesting argument. We'll see if he prevails or not.
No question. We'll certainly be keeping an eye on that. All right, Roger Futerman, thanks for the wonderful insights. Truly appreciate it. Stand by. We're going to take a quick break right now, but when we come back, it'll be time for our Talk Back segment. We're going to take a look at the news out of Idaho in the Molly Tibbetts murder trial, where the defense claims there is newly discovered evidence that should result in a new trial. So we asked you, should Christian Bahena Rivera be allowed to have a new trial based on that evidence? Your comments coming up next right here on Court TV. Don't go anywhere. Attorneys for Christian Bahena Rivera are asking for a new trial in the murder of Molly Tibbetts. They say that since their client was convicted, a person has confessed to killing Tibbetts as part of a sex trafficking scheme. And that brings us to today's Talkback segment. Each day we post a question on Court TV's social media pages. We gather your comments and questions and respond right here on the show. Today's question, do you think Christian Bahena Rivera should get a new trial in the killing of Molly Tibbetts case? All right, still with me is criminal defense attorney and former state prosecutor Roger Futerman. And we'll get right to our first comment of the day from Glenda Belt. He's guilty. He knew a lot about what happened to Molly, and now this. Hopefully this judge will refuse a new trial. Now, Roger, you weren't involved in our earlier discussion about this case. I'd love to get your thoughts in general about this idea that this defense team is pushing forward. There's this new evidence, and they want to open up this case and get a new trial. Again, very difficult to do.
Difficult to do, but it's very unusual for the situation to come. What I don't know, if the prosecutors knew about these witnesses, why they would give that information right after the trial. That seems very, very odd to me. And I'm not familiar with that state's discovery rules. In Florida, you have very liberal discovery. Certainly, if you're aware of that, the prosecutors have an ethical duty to turn that over. So I don't know why they did that right after the trial. For what's called Brady evidence, exculpatory potential evidence. Someone says, I'm the one that committed that murder. That should be revealed to the defendant before the trial, not after the verdict.
Well, what's interesting in this case, there were two separate incidents of information being brought forth. One was given to the defense prior to trial. The second one wasn't given till after the trial because someone determined that it wasn't necessary to give it over. And that's the defense argument, that initially when they heard the first one, it didn't seem important to them. They didn't want to use it. But when combined with that second one, they said now they have something that certainly would have made a difference at trial. All right, let's go to our next comment from Alicia Isaac. The defense team made a great argument today. Unfortunately, I'm doubtful the judge will go for it. Heartbreaking for those of us who believe in Christian Bahena Rivera's innocence. And I want to point out again, and Roger, maybe you can back me up on this, the fact that it's very difficult because what you have to do is not only show that this was new evidence, but that this new evidence would have an effect on the trial, that in fact it would have likely made a difference. And that's where a lot of these activities stumble.
100% correct. Not only would the evidence should have been discovered, but it would have changed the outcome of that case or potentially changed it. And so you're right, it's very hard to get a new trial on those grounds. But you do always wonder, why would a prosecutor not turn that over? Not necessarily, I'm not saying that this man isn't guilty. I'm just saying from a prosecutor's standpoint, why would you not turn it over? What do you have to gain by holding it back? You have the case, you have this other evidence, just give it. And I think it's a good rule for all new prosecutors to learn. Give if in doubt.
Absolutely. Always turn it over, but it doesn't always work out that way. You and I both know that's the case. Roger Futerman, thank you so much for being with us. Pleasure having you. It's been a pleasure being with you as well. Up next, closing arguments with Vinnie Politan.
In Poweshiek County, Iowa, new evidence revealed in court in the Molly Tibbetts case as the attorneys representing the man convicted of murdering Molly name the man who they say confessed to the killing.